Hello students, how are you? I hope you are fine. This lecture is specially for those students who are preparing for their judiciary exams, and even for those students who are keeping law as their mains IAS subject, and even general who are interested in law. They must keep note of this important topic, and this topic is live-in relationship. What is the legal status of live-in relationship in India? Is it legal? What about the society? Does society considers live-in relationship still immoral or moral? So let's discuss, let's start. The first case in which Supreme Court actually recognized live-in relationship in India was Badri Prasad versus Deputy Director of Consolidation, 1978 Supreme Court. I will be giving the names of all these cases which I am referring here in this lecture, and you can note it down just by going to the description below to the video. So this was the first case in which the Supreme Court actually recognized live-in relationships in India, and in this particular case, Badri Prasad case, there was a 50-year long live-in relationship, and the court actually recognized that. Then the second case is Tulsa and others versus Durghatiya and others, 2008. In this case, Supreme Court provided legal status to the children born out of the live-in relationship, and they will be treated as legitimate now after this case, not illegitimate. Earlier they were treated as illegitimate, but now from this case, Tulsa and others, these children who are born out of live-in relationships will no longer be treated as illegitimate, but there is some precondition for that. There is some prerequisite for that, and that prerequisite is that the parents must have lived under one roof and they must have cohabited for a long time, considerable long time, for the society to regard them as husband and wife. Now how much time? It depends upon case to case. It depends on fact and circumstances of each case. No hard and fast rule, 10 years, 20 years, 30 years. Even in Badri Prasad case, it was 50 years. And cohabited means living as a husband and wife, performing the duties of a husband and wife, having sexual intercourse. So this was the ruling given in Tulsa and others versus Durghatiya and others, 2008. Then one more thing. There was the opinion of the court that it should not be a walk-in and walk-out situation. It should not be a one-night stand like that. So it should be a permanent relation, long-time relation. Court also granted the right to property to the children born out of such type of relationship. Then the third case is D.Velusamy versus D.Patchaiammal. D.Velusamy versus D.Patchaiammal, 2010. In this case also, the court held that one of the prerequisites or conditions of a live-in relationships is that couple must have voluntarily cohabited. That is, they must be performing the duties of the husband and wife, and they must have held themselves out to the world as being akin to the husband and wife. They must show themselves to the world that actually they are husband and wife, and this must be for a significant period of time. Also, the court held in this case that not all the relationships will amount to live-in relationship, or not all the relationships will amount to relationship in the nature of marriage. This relationship in the nature of marriage, this word or this line is included in section 2 clause F of Domestic Violence Act 2005. Domestic Violence Act actually protects this type of relationship, and though it's not a valid legal marriage, but Domestic Violence Act actually protects this type of relationship. This is the first act which actually recognizes live-in relationship, and protection can be given to the woman in this relationship. Maintenance can also be given to this woman. So this woman of the live-in relationship, in case the man does not support her or does not provide maintenance to her, she can get maintenance by the virtue of section 2 clause F of Domestic Violence Act, and that is the relationship in the nature of marriage, and she can get benefit of this act. If a man keeps a woman as his servant, this was also said in this case, if a man keeps a woman as his servant and maintains her financially and uses her just for or mainly for sexual purpose, such relationship would not be amounting to marriage, or even in the eyes of law, it is no marriage, and even for that matter, it cannot be regarded as a live-in relationship also, because that woman actually, she is a concubine, she is not in a live-in relationship, so permanence is not there. Hence, no benefit of Domestic Violence Act 2005 or even maintenance can be given to such a woman. but I think the law must be changed, and even these type of women who are not permanently with that person, they are only used by that person for sexual purpose, they should also be included in this Domestic Violence Act, and they should be protected by the law. Okay, then the fourth case is as Khushboo versus Kanniammal and another 2010. In Khushboo case, the court held that living together is not illegal in the eyes of law, though it may be considered immoral by the considerable part of our Indian society. It's our conservative Indian society who considers this type of relationship as immoral. But the court said in this case that law doesn't go into these things. According to law, it is legal. Court said that living together is the right to life exercised by both the couple, and this right is given under Article 21 of the Constitution of India. Therefore, it is not illegal for a boy or a girl who are adult, that is more than 18 years, to live together. Then the fifth case is Indra Sharma versus V.K. Sharma 2013. Very important case. In the Indra Sharma case, the court recognized 5 categories of live-in relationships. The first one is adult male living together with adult female, and both are unmarried. This is the most simplistic form of live-in relationship. And the second is married man living with adult unmarried woman. Third is married woman living with adult unmarried man. And the fourth one is married man living with adult unmarried female. And the fifth one is relationship between same sex partners, that is gays or lesbians. So in this Indra Sharma case, in this case, court also said that live-in relationship will fall within the expression relationship in the nature of marriage, as it was held in the earlier case. Same in this case. So live-in relationship will actually fall within the expression relationship in the nature of marriage as defined under section 2 clause F of the Domestic Violence Act 2005. And this relationship must be protected, and especially women of who are in these type of relationship, they must be protected by law. But in the above this particular Indra Sharma case, the relationship was actually not in the category of domestic relationship as defined in section 2 clause F. Similarly, it was not, according to the expression, it was not included in the expression relationship in the nature of marriage. Actually, in this case, the woman already knew that the person with whom she is living, he is a married man and having 2 kids and a wife. So she already knew this. So, and it was not a live-in relationship also. It was not permanent. This woman was not having any kids also with that man. So she was not given protection of this Domestic Violence Act, particularly in this Indra Sharma case. There must be amendment in section 2 clause F so as to include these type of women also in the category of relationship in the nature of marriage. This is also domestic relationship, but the law is quite on this law is mum on this point. Now the legislature should consider this also, because these women are most vulnerable sections of society. They must also be protected. And the guidelines given by the court in this Indra Sharma case are whether to consider certain relationship as a live-in relationship or not. These are the guidelines. Court will see the duration of the relationship, shared household, are they the couple living under one roof, then whether there is a sharing of resources by both of them. This is also one of the consideration by the court to see whether it's a live-in relationship or not. Are the couple supporting each other financially? This is also very nice or good thing to know whether it's really a live-in relationship or not. Then the other point is whether they are sharing bank accounts, whether they are having joint bank accounts. This is also one of the important markers whether it's a live-in relationship or not. Then the other one is acquiring immovable property in the joint names or in the name of the woman. Then the other one is doing domestic work jointly. Both the couple are doing their domestic chores jointly. Whether woman has been entrusted the responsibility of running the house, do household activities like cleaning, cooking, because generally these type of things are done by the woman. Generally in Indian patriarchal society, upkeeping and maintaining the house. If she is entrusted with these things, if she is entrusted with these activities by the person with whom she is living, obviously she is living with him in a live-in relationship, and that relationship has to be protected by law. She should be protected by law, and she should be given maintenance and protection order under Domestic Violence Act. then even under section 125 CRPC, she can be given maintenance. These all are the indications of relationship in the nature of marriage as defined under section 2 clause F of the Domestic Violence Act 2005. Whether there is sexual relationship between both of them, this is also one of the indication. Now this sexual relationship between both of them should not only be for pleasure. This sexual relationship should be an intimate relationship, as a relationship between a husband and wife. That sexual relationship would be for procreation of children, for emotional support, for companionship, and even for caring. And the other indication of a live-in relationship is having children. Having children is a very strong indication of relationship in the nature of marriage. Then the sixth case is Dhannulal versus Ganeshram 2015. In this case also, the court said that the woman who is in live-in relationship would be eligible to inherit property after the death of her partner. This is very important. Even the children born out of the live-in relationship, this was said in this case, even the children born out of the live-in relationship shall have the right to self-acquired properties of the parents under section 16 of the Hindu Marriage Act. But as far as present situation is concerned, now at present, children born out of the live-in relationship can even claim ancestral property also. Besides separate property of the parents, the children can claim the separate property of the parents as once, because the logic is here is, what is the logic? Why they can claim ancestral property? Because once the law declare them legitimate, they are no more illegitimate, then by law, then they should be provided with all the rights of the legitimate child as given under section 16 of the Hindu Marriage Act. Then the last case in this discussion is very important case, Nand Kumar versus State of Kerala 2018. It's a recent case, very recent case. In this case, it's a very interesting case. In this case, there was a boy and his name was Nand Kumar. He was less than 21 years of age. Then the girl's name was Tushara. She was actually 19 years of age. It means both were adult. They both were above 18 years of age. Now what happened? There was a little bit intimacy between both of them. This was in Kerala. They married in a temple on 12 April 2017. Now after marrying in a temple, they started living together as a husband and wife. Now father of the girl Tushara filed habeas corpus petition in Kerala High Court. The Kerala High Court, after hearing that habeas corpus petition, in that petition the Kerala High Court opined that the girl is not legally wedded wife of that boy, Nand Kumar. Why? Because Nand Kumar is not of marriageable age, as I've already told you, he was less than 21 years of age, and because of this, she is not a legally wedded wife. And this was the precondition under section 5 of the Hindu Marriage Act, which says that for valid marriage, the girl should be above 18 years of age and the boy should be above 21 years of age. But here the girl was more than 18 years of age, but the boy was less than 21 years. So the High Court said that she is not a legally wedded wife. Now boy preferred appeal to the High Court against this High Court to the Supreme Court. He went to the Supreme Court against the High Court's order. Now Supreme Court said that both the boy and the girl are more than 18 years of age, though boy is less than 21 years of age. But even both of them are more than 18 years of age. It means they both are major, they both are adult. So both have the right to live together even if they are not married, even though they were married, but even outside wedlock, that even if they are not legally married, they can have a relationship, and that is actually live-in relationship. Supreme Court set aside the Kerala High Court's judgment. Supreme Court said in this case that the girl Tushara has freedom of choice. That is, it is she to decide with whom she wants to live, not anybody else. Because she is major, she is more than 18 years of age, she is exercising her right to life under Article 21 given to her by the Constitution of India. So this was the lecture about live-in relationship. I hope you liked it, and let's meet in a new video on some new topic. I hope you like this lecture. Till then, bye bye, take care. Thank you very much.